everybody. I'm going to give us a few seconds, maybe a minute or two for everybody to log in. Over 400 people registered for this webinar, which should tell you something. M&A is hot right now in the cannabis industry and has been for some time. 2021 basically broke some very interesting records around acquisitions, a lot of consolidation. 2022 shows no signs of slowing down. And even more states are going to come online with medicalization and even adult use via their legislatures. And then, of course, November ballot initiatives. But today on this panel, the four of us, I will moderate. This is Hillary Bricken. I'm coming to you from our LA office. We're going to talk about corporate cannabis relative to mergers and acquisitions. And instead of having individual canned presentations between our three speakers, it's really going to be more of a Q&A dialogue based on the questions that you submitted beforehand, and really the questions that we have for each other based on experience and recent deal making across the country, to be honest. So I'll let each of our panelists introduce themselves in turn, and then we'll go ahead and get into the questions. I'd like to start with my colleague and partner in our Portland, Oregon office, Vince Sliwoski.
Hey, everybody. Yeah, thanks for tuning in. My name is Vince. Thanks for the intro, Hillary. I am here in Portland. I'm a business and real estate, commercial real estate lawyer. I've been doing cannabis work almost my whole career, since 2010 or 11. I think it's when we picked up our first medical cannabis clients here in Oregon. And we've done a ton of M&A in the last, I'd say 3 to 4 years in Oregon. That's when the market really heated up. And I've worked on a lot of those transactions with both Natalie, who's licensed here, and also Griffen, who's licensed in California. So look forward to it, and I'll let those guys self-introduce as well.
Yeah, Griffen, why don't we move to you for your intro?
Hey, everyone, I'm Griffen. I'm a lawyer in Harris Bricken's LA office. I started off my career litigating business and IP disputes, moved into privacy law, and now do exclusively corporate work. We represent lots of cannabis companies. A large part of the corporate work I do is finance related, some real estate, and then M&A, which is really, those are the three areas I practice on most. I've worked a lot with Hillary, Vince, and even Natalie on M&A transactions all over the West Coast, and specifically in California. So I'm here to answer any questions and just give everyone the rundown.
And Natalie, why don't you give us your intro?
Yeah. I'm currently based on the East Coast. I relocated here a few months ago. I was working out of the Portland office and been working with Vince for almost 4 years now on all of these transactions. And hopefully pretty soon, my colleague Simone, who is in New York, and I will get to work on these deals with clients who are on this side of the country.
Fair enough. I'm going to go ahead and kick off our panel because we only have an hour today. And just as a reminder to everybody that's tuned in, please feel free to submit your questions during the webinar. I will see them. I will ask them if there's time. And as long as they're relevant to the topic, you can rest assured I will do my best to get to them. I, too, have done a ton of M&A in the space in California, in Washington. In 2020, our firm closed over $1 million of transactions, which was pretty outstanding for a firm of our size. That's how busy things are in the M&A department. So without further ado, we're basically going to take it from top to bottom with both business purchases and asset purchases and what we see in a variety of states because they're not all the same. And the first question that I have for the panel, and anybody feel free to take this, do you need a letter of intent in place before you sell your licensed cannabis business?
I guess I'll take that one. I'd say it depends if you're just selling a naked license where the terms are pretty straightforward and it's just a matter of agreeing on the purchase price and then the payment methods. If you're using an escrow agent, for instance, then I generally don't see the need to incur legal expenses and wait, to start drafting an asset purchase agreement. So that's typically what we'll advise clients who are just selling a license. Now, if you're also selling equipment, inventory, or if there is real estate that's also involved, where the terms are a little bit more complex and you have to agree on many more issues, then I think a letter of intent can make sense. Also, if you're using binding provisions in an LOI, that's a way to make sure that no one is looking elsewhere, and that you're moving forward with this particular buyer until really you draft the final agreements and then execute them. So yeah, in a nutshell, that's what I would recommend for otherwise.
Very good. And then as far as the commonality of structures, we get this question a lot. A lot of folks in the cannabis industry have not actually engaged in M&A pretty much ever. So they want to know off the bat, whether they're the buyer or the seller, what are the common structures that we're seeing in the marketplace, probably in the last 2 years for these M&A deals?
I'll take that one. So sort of to rip off of what Natalie was saying, M&A encompasses both mergers on one hand and acquisitions on the other. Mergers when two businesses combine and one of them survives with there's just two combined businesses essentially. Acquisition is when people or a company buy another company, right? And so acquisitions can also be asset acquisitions in this space, depending on the state. So Natalie was talking about buying a license. Can't do that in all states. You can't do that here in California. And so you typically, if you're doing purchase transactions, you're going to see either a membership interest purchase agreement if it's an LLC, or stock purchase agreement if it's a corporation. Other states like Oregon, you might see asset purchase agreements. Where they're possible, I think asset purchase agreements are generally better because you're buying the assets of a company, which will include the license and the inventory and whatnot, and not the company itself, which may have all kinds of tax and other undisclosed liabilities. So the risk for a buyer is much, I'm oversimplifying this, but it's much less insane in a asset purchase deal than it is in a stock or membership interest purchase deal. But again, largely dictated by state regulations. So that's where cannabis differs quite significantly from basically any other kind of business you'd see.
Yeah, and I think sometimes that's lost on the basic M&A practitioner. They don't realize that the regulatory invades the transaction, which is a nice segue into our next question, which is, do you have to buy the business structure or the license? Can you do a hybrid of both? Is it state dependent? Is it local dependent?
So I could try to answer that. I think sort of dovetailing off what Griffen said too, because the two questions are tied together in my mind. A lot of times it's really situational, right? Sometimes a seller will say this absolutely has to be a stock sale because we're taxed at a lower capital gains rate, and if I sell assets, I'm going to get killed, right? Other times you're able to get away with an asset sale, which people generally prefer. They're simpler agreements, they're easier to negotiate, and they're almost sort of cultural, I would say, to like the Oregon cannabis industry, for example. Everybody's just always buying assets, and that's the way it works. You don't have to worry so much about liabilities you may be assuming in disclosures. You can kind of deal with all that in reps and warranties and disclosure schedules and stuff. Anyway, can you buy a license in these transactions? Technically, short answer is no in most states. You know, states tend to consider a cannabis business operating license in the way that they consider any other license they may issue to you. So it's kind of like a driver's license or a hunting license. It's personal to the person or entity that holds it. You can't say, okay, I have a driver's license, I'm going to go sell it to my friend over there so he can drive a car. Or I have a hunting license, so I'm going to sell it to this other guy so he can go on the hunt, right? You can't do that. So what the state will do in some situations, like in Oregon here, they will work with the buyer and the seller. They'll say, okay, we understand that this business wants to sell to somebody else. What we're going to do is cancel the seller's license and issue a buyer's license concurrently, right? So when we phrase that in the purchase agreement, asset or stock purchase agreement, we talk about somebody buying all rights, title, and interest in a successor license at the premises, that kind of a thing. People often confuse the concepts, but generally speaking, at least in Oregon and in many states, you cannot straight up buy a license. That's something personal to you issued by the state.
Sorry, I was muted. I do want to correct something that I said earlier at the top of the hour. Closing 1 million in transactions in 2020 really wouldn't make anybody bat an eyelash. I want to correct that. It was actually 100 million in transactions. So it's a much bigger number for us at Harris Bricken regarding our experience with M&A. And Vince, I appreciate you saying that because, again, I think a lot of people, when they talk about the transferability of licenses, and especially when they do letters of intent, the letter of intent may outline a license acquisition that is not even possible under the law, and therefore the contract's not enforceable, probably even illegal. and the regulators are going to shoot it down. So it's super important to know from the outset what you can and cannot sell in these jurisdictions. And we have seen some very interesting behavior where occasionally we'll come across a buyer that's not so concerned about the regulatory impact, which when that happens, we have to really contemplate what the dispute section is going to look like in the contracts. Moving on, and this is a very important question that we get a lot, and we even have a question about valuation in the chat box, but how are buyers financing transactions these days? And kind of a dovetail of that, probably maybe 4 to 5 years ago in cannabis, the valuation numbers were super pie in the sky, very frothy. Many of them were even pre-revenue, so no substantiated record of doing business. They've come down considerably, but does a deal like the GW Pharma, Canopy, those deals in the country, do they affect valuations universally, or is it still more of a local game because we don't have interstate commerce? So it's really not some kind of comparable metric that we can measure all businesses against when those deals come to fruition.
I can answer part of that question. I'm not as familiar on the valuation side and specifically the effect of that specific transaction on the valuations of smaller deals. What I can say is what we see typically is when you see the bigger companies, when they buy a cannabis company, a lot of the time part of the purchase price is paid in stock in the Canadian parent company as opposed to cash. So it's not the same thing as financing, but that's how you say that's how a lot of these deals get structured. In the smaller deals, there's a lot of debt financing or even seller financing going on where let's say there's $1 million purchase price, half of that's paid up front, and then the rest is carried over with the seller note that's paid over around 3-5 years with an interest rate that's usually pretty significant given the nature of the industry. So, unless you have a buyer who's like got the cash on hand or a very small deal or something, there's usually some element of financing or paying in stock or something like that. Another thing you might see is earnout, post-close earnouts. So that basically, rather than paying a high purchase price up front for a business, or we don't necessarily know it's going to be successful, we will promise the sellers that if they stick around and help the business succeed, like in the capacity as a chief executive officer or something, they'll essentially get bonus earnout provision payments, later down the road. And those benchmarks and the timing for all that is usually heavily negotiated. And there's really no such thing as like a one-size-fits-all approach to this. So a lot of it's just business to business negotiations, and then legal will come in and figure out how to make it work given cannabis regulations.
One thing I'd add to that I've actually seen people screw up a lot is when you have a seller carry transaction, and especially when you have an earnout, it's often the case that the seller still retains a quote unquote financial interest or ownership interest in the business under the regulatory rules. And it's important that that's understood by the parties. The buyer needs to understand that could implicate down the line some risk to the license if the person misbehaves, even if they're not active in the business. And it's important to understand they need to be disclosed probably still after they sell the business in the first place. And again, each state's sort of a snowflake in terms of how strict they are in disclosure of owners and things like that. And some states have evolved over time. Oregon used to be a lot stricter than it is now. But if you fail to continue to list an owner or a financial interest holder, as this case may be, you could be in some regulatory hot water. So I always encourage people to think those things through too when they're talking about earnouts and seller financing.
So we've talked about whether or not to have an LOI, the regulatory impact from the outset of the deal that you should understand, considerations for buyer financing and seller carried transactions. Now the phase of the deal, depending on the parties, typically moves into diligence. And diligence is a dirty word for lawyers. It makes us very nervous for a variety of reasons, because there can be lots of bodies buried around the sellers, the target assets, the business itself. And it really takes a skilled, experienced attorney to know the questions to ask. And this is not run-of-the-mill M&A. There is going to be a robust probe on the regulatory compliance, because you need to know that you're not buying a license or a business where the licensing is going to expire. What are some of the best ways to propound diligence, target diligence at the sellers and these companies, and especially when we're dealing maybe with legacy operators that don't have a lot in writing, which we still do have in Washington, Oregon, and California?
I do. Oh, sorry, Natalie, go for it.
Yeah, when it comes to due diligence, if it's just a license, usually states, I mean, I can speak of Oregon because that's where I practice and have the most experience. You can actually submit a formal request with the OLCC, which is the Cannabis Board in Oregon, in order to check on the status and the standing, the good standing of a license that your client is about to purchase. The downside of going through that formal process is that it takes a very long time to get a response. So the way we've gone around that is to set a certain period of time for due diligence, but then include very solid representations in there from seller, basically saying that if they materially breach under the asset purchase agreement, that we would be able to terminate the agreement. And that would be a way to hold them accountable to keep the license in good standing until closing. So that's kind of the key issue there when you're dealing with a license. Now, if it's due diligence for other types of assets, like reviewing books and records for the company, that's just a different type of due diligence process because we're not dealing with the regulatory agency. That's more traditional and similar to what you would be doing if you weren't dealing with cannabis. But yeah, I think the main due diligence piece when you're dealing with cannabis is to make sure that this license is in good standing until the very end of the deal.
Yeah, I want to add to that too, because someone is asking what is the important stuff you want to ask for in these deals, and basically the answer is everything. When we do these things and we get pulled in to do a diligence transaction, we'll send at the beginning of the relationship a lengthy questionnaire, right? With people are supposed to answer the questionnaire, at least in theory, if they do what they're supposed to do, and provide documents and provide information. Then we look at it, and the accountants look at it, and like anybody else who needs, any other professionals that need to look at it to make sure that the sellers are actually saying the truth, right? Typically it devolves into a long process where there's follow-up questions and the follow-ups and the follow-up questions, and then we have to tell our clients, hey, maybe they're not being candid with you, or maybe this one thing, there's a huge outstanding risk. But typically the things we look for, I mean, just at a very general level, we want to see all the corporate governance documents. We want to see material contracts, so contracts that the business we're buying has with third parties. We want to know about litigation or threatened litigation or arbitration. We want to know about intellectual property registrations that the business has, tax issues, outstanding taxes, outstanding debt. Those two are probably the most important issues for any buyer, right? Because who wants to buy a business that's strapped with debt? At least that they don't know about, right? And then I'm trying to think about some other stuff. Real estate matters, what property they own, what property they lease. That one's actually important because one of the most painful things to deal with in an M&A deal, in my experience, is a landlord. When you come in and you're buying a business, all leases have provisions saying the landlord has to consent to new owners taking over, and getting them to consent to that can be a pain, and they have absolutely zero incentive in most cases to work with you and be friendly and things. So Vince and I can tell you some stories about crazy stuff we've seen back in the day. Probably not going to do it here, but yeah, it's really key to diligence stuff early and do it hard. And that way, the benefit of doing good diligence is that if something the sellers say turns out to be false, which again, we've seen that happen multiple times, they've then committed fraud, and they've omitted something and or intentionally misled you, and you have way better claims against them than just breach of contract, in my experience. And you might not be able to get them on a fraud claim if you don't ask the right questions. So it's really key to get a lawyer who knows diligence stuff to really go hard on a seller.
Diligence can be a good exercise too for knocking down the purchase price sometimes. You get into it and you find some undisclosed liability, and all of a sudden, whoa, why would we pay all that for your business? Look what we found. So I just think people buy these things. Sometimes people get excited and they plow through these deals and they don't care about the diligence. And that happens more with real property than business assets, but it happens with business assets too. And we as lawyers are sometimes saying, hold on, we don't want to throw a stick in the spokes to your transaction, but do some really basic diligence here, because it's like insurance and then some. So I would encourage anybody here to really think through it. And I really like what Natalie said. If there are public records out there, you can go to your regulators and you can get stuff like that, get it. We had one situation where a buyer representative warranted that there were no enforcement actions against their company. We get a week out from closing after this long, protracted, drawn-out thing, and all of a sudden the agency says, oh, we can't transfer that license. These people are under investigation. They might have their license canceled. Well, the sellers didn't disclose that. If the client had done that kind of diligence, they would have known that long ago and saved themselves a lot of headaches. So good points all around.
Yeah, and I will say, if you're getting pushback from a seller on basic due diligence, it's a huge red flag, because when you're selling your business or its assets or substantially all of the assets, you open the curtains, right, to shed light on everything you've got. They should not be hiding the ball on liabilities. And really, I would say the 2 to 3 main areas are regulatory, license, good standing, history violations, verbal and written, taxes, including 280E and local and state taxes. The 280E liability is a death knell if that's not taken care of, at least on a payment plan or potentially in litigation if you're comfortable with that. And then obviously, if something comes up with diligence, and we're going to talk about this, getting the right reps and warranties in place. We've had way too many people come to us after the fact, after there's been closing, where even though they knew that there was a defect in diligence as the buyer, right? And even though the seller provided reps and warranties saying, these are clean sheets, we have no problems, the buyer proceeded anyway, knowing that none of that was true. And that completely invalidates your ability to pursue the seller for corresponding damages. So don't be a rube. If you see something come up in diligence, say something. And if the seller's pushing back, that pretty much speaks volumes. And I don't think anybody on this webinar would disagree with that. We do have a question, and this is an important one. If the M&A is screwed up, right? You screw up the change of ownership, you transfer a license when you can't, what have the penalties been, including for things like failing to update who the new owners are, getting approval of the new owners? It all works a little bit differently in every single state. Is it an administrative slap on the wrist, or are we talking complete forfeiture of the license?
I mean, I think you were right in the it depends answer, and people hate that answer, and lawyers are famous for giving that answer, but it really is different state by state. We've seen some really big companies like Curaleaf get fined. I think it was $100,000 they paid out in Massachusetts for doing exactly what Hillary just described. We've had clients here in Oregon who've got notice of proposed license cancellations for stuff like that. Usually we're able to go to bat for them and get something worked out. But I mean, yeah, worst case scenario, you lose it all. It's just not something to trifle with. It's so easy to update disclosures. It's just got to do it timely and do it right.
Right. And definitely people need to know this on changes of ownership or license transfers. There can be deadlines by which you have to report. It's not an open-ended option, at least in the state of California. Formerly, it was 10 to 14 days from the effective date of the change of ownership to tell regulators and start the approval process. Now, I think, Griffen, it's to 14 days for all license types to get that change in from the date of the transaction, essentially. You miss the deadline, you're not going to have a lot of defenses around it unless truly something came up that viably prevented you from notification. We have a form for it and everything. So it can end up being a big deal to regulators. And if you don't have good defenses around why you failed to report, you're at least looking at some kind of a monetary fine and up to license cancellation in most states. Now, next question, and this may be a basic one, but this gets skipped a lot actually by both experienced purchasers and sellers and the not so experienced. When does the panel think you should even bring in an attorney? Because we see people all the time negotiating their own LOIs. They get right up to closing and then they're calling a lawyer. So when ideally should people be giving us a ring?
I'll let one of you guys try that one. I mean, I've got thoughts on it, but go ahead. Maybe Natalie could answer that one.
Sure. Well, again, it depends, but I think the sooner the better, especially with the LOI. I think we see people coming to us who enter into LOIs that only contain binding provisions, which I think is really dangerous if you're doing that without an attorney who is providing guidance and counseling you throughout, because you may agree to a purchase price that's way too high, or you may agree to, doing things that maybe are not in your interest because you're not familiar with these regulations that apply to the purchase or sale of a license. And so in my experience, the sooner the better, so that you don't go to an attorney to then undo a mess, which ultimately is going to cost you more money than if you had hired a firm like ours from the get-go. But if you're a sophisticated seller or buyer that has done a few of these transactions, then it might be more appropriate for you to enter into an LOI without consulting with us first, because you already have a pretty good understanding of what can be done and cannot be done, and then come to us to draft these documents. But since every deal is pretty unique, I think it's always a good idea to have these definitive agreements, the purchase agreement, be drafted by an attorney, because again, these slight changes can have pretty significant impacts. And so don't just rely on past deals and repurpose agreements. But yeah, those are my 2 cents on
I think
that.
it's good to, if you talk to a reasonable attorney, if somebody comes to me and they want me to jump in and do all this stuff, sometimes I'll say, well, I don't know if that makes sense yet. Like, hold on, or go to this and then come talk to me, right? Just because you tell your attorney a deal may be, on the way or something, doesn't mean you're suddenly on the hook for $50,000 or some crazy thing, right? The attorney is going to sort of talk with you, work with you about when their role should really kick off, what their role should be, those kinds of things. And you get to authorize them doing anything. You get to authorize them drafting anything. You get to authorize them calling the other side's lawyers, whatever it is. So I think, like Natalie said earlier, the better, sort of a precautionary principle thing. And good lawyer will sort of guide you through it and step in when the time is right to step in.
Yeah, and a solid M&A lawyer is also going to tell you what's customary. If you've never done one of these deals before, you're going to be in charge of a lot of the business decisions, right? Like the consideration that's paid, what you're willing to commit to, the timeline on the deal, any other performance logistics. But really the value add is for the lawyer to be able to say, I've done this before. This is what's normal and customary. This looks out of sorts. And then, of course, you want somebody with that regulatory background. And we've helped lots of firms, including really big ones, even just do the regulatory part on M&A because it's so overwhelmingly important to the life of the transaction. Now, another basic question that some of you may be surprised that we get, but you really shouldn't be because it is kind of dynamic. What is a closing? A lot of people are very confused about what a closing actually is.
I could take that one. So in regular deals, like not M&A deals or finance or real estate deals, if I was just doing some sort of supply contract, you sign a contract and everybody gets to work, right? In a business purchase, you don't, typically speaking, sometimes this is done differently for various reasons, but like you'll sign a contract after some negotiations and some diligence. Certain things will happen, like for example, in a state like California, you'll go notify the local city or county and start the local change of ownership process. And once those various things are done, you'll get the landlord to sign off on it, which, as I said earlier, is a nightmare a lot of the time. The seller may be forced to clean up some books and records and taxes and debts and whatnot. Once all that stuff is done, which is all predetermined in the contract, then you close, so to speak. And to simplify this, essentially, they give you the keys to the business, you give them the dollars, and then that's it, right? Some deals get structured with multiple closings, like California. California was common. It's still common to structure the M&A deals where some part of the business is sold up front, the rest is sold after you get final state approval. So you might see multiple closings, but generally speaking, that's kind of how it works.
Right on. And, you mentioned having to notify the local government of what's going on before anybody pulls the trigger around a closing. And just a footnote for our audience, the state and the locals do not always agree. about how changes of ownership should proceed, notification requirements. There could be local hearings around the change of ownership. Some cities are extremely sensitive to new operators coming in, more sensitive than maybe even the state. I digress, though, because I mentioned the local government footnote because it's typically a common closing condition. It's got to happen, take place, be successful before the money or whatever consideration changes hands for the business or the assets. So who wants to take the question about what are some of the common closing conditions that we see specifically for cannabis and then M&A in the context of cannabis generally?
I can take this one just because I wrote a pretty lengthy article on our blog recently about this specific issue. And I also was just talking about it. So number one, yes, city approval in California is absolutely key. The vast majority of local jurisdictions require some kind of approval before you can change ownership. Whereas at the state level, which in my opinion is incredibly stupid, you just notify them after. So if the state decides to deny your request, you have to go back and unwind the deal somehow. It's a really silly system. Another common one would be paying off debts. If you know the business has a debt, part of the conditions to closing might be paying that off. It maybe even means paying it off with some of the purchase price proceeds simultaneous with the closing. Landlord approval is always going to be one that's necessary so long as the business has a lease, because like I said, every single lease will have a provision saying the landlord is entitled to consent to the owner of the business changing. We will see things like settlement of litigation potentially. If there's active litigation, we want that to be settled. Transfer of ownership of intellectual property rights. You name it, right? So there's just a whole host of things. But if we're talking cannabis, and even to some extent CBD, if you're in a jurisdiction where CBD has licensing involved, there very well may be change of ownership things that need to happen up front. So that's really good. I mean, Hillary and I have been brought in on some deals to clean up where cannabis or non-cannabis lawyers have done M&A deals. And like oftentimes the change of ownership stuff is just not even considered, like nothing. Or it's 100% change of ownership that we see, and that's not allowed under California law, or at least at that time wasn't allowed. So just like the regulatory change of ownership process can be one of the most daunting, and that usually needs to happen up front.
Okay. And then regarding things like undisclosed liabilities, because maybe no seller is perfect. Maybe they don't even know, or they do know, and they seek to deceive. In the transactional documents, what are some of the best ways to protect against those, including common reps and warranties that we're seeing?
Reps and warranties is a big one. Holding back cash is a big one. I like doing that a lot. If I'm representing a buyer, I like to hold it back as much as I can for as long as I can. So, to protect against something that comes out of the woodwork, it's kind of nice if $500,000 of the deal is still sitting in escrow and I can claw it back. Those kind of mechanisms and contracts are really, really big. Sometimes people mess around with liquidated damages provisions and stuff, but things like that. I think it just kind of ties back more or less to the concept of do as much diligence as you can and then have all of that standard contractual protection stuff baked in. And I realize, like, for these businesses, some of the stuff is hard. They're cash businesses. Record management's pretty poor for the most part, but that's sort of not an excuse to write off the process and the protections. I mean, if they don't have standard P&Ls and financials, at least get into the point of sale system. Do something. Do whatever you can. And if you're willing to accept some risk, then yeah, in the contract drafting, hold back as much money as you can. Get the best reps and warranties you can, et cetera, et cetera. That's big picture how I think about it.
Anything else to add, guys, before we move on from that one? Because it's a pretty big one.
Yeah, I guess the only thing I'll add is that there's a knowledge standard. So a representation warranty is a promise, right? So someone in the contract is going to say, I represent and warrant that the company doesn't have any taxes that are outstanding or doesn't have any debts that are owed to any third parties. And all of that's going to be qualified typically with a knowledge standard saying, like, if it's a company that's making this representation warranty, we're going to say that the representation is made by somebody at the company who has a specific level of knowledge. Actual knowledge means it's something that person actually knows at the time they're making this promise. Constructive knowledge, is what you always want to see as a buyer, means not only things that they actively knew, but the things that they should have known with reasonable diligence. So if they get an envelope from the IRS that's 6 inches thick, and they just don't open it, right? Prior to closing. Well, and it turns out they owed, hundreds of thousands of dollars. Like, yeah, I guess they didn't have actual knowledge about something, but they should have known, they should have opened it, right? So this can be a huge point of contention in negotiations and deals. And if you're the buyer, you always want it to be constructive knowledge. The looser you can get it as the buyer, the broader that is, typically the better.
Right. A third lever that I would add in there that we haven't mentioned yet is indemnification, basically to protect against third-party claims that may crop up from how the business was previously run. I can guarantee you in cannabis, there's a lot of those that may not actually come out in diligence because maybe the seller doesn't think it's relevant, or it's not possible, or it's not going to happen. In California, we had big problems because previously, before Prop 64, prior to 2016, most if not all of our operators were nonprofits. And then once legalization hit, they all wanted to convert to for-profit entities. Well, there's a whole corporate process that goes in to that conversion that requires notification to essentially what are de facto shareholders, or they end up being the shareholders in the new entity. A lot of people skipped over that particular step. And in M&A, you would rep and warrant for that and get indemnification for those claims in the event anybody came out of the woodwork saying, where's my piece of the purchase price? And again, that's very particular to cannabis. It's standard anyway. But because of the history of some of the operators here, indemnification is also really important. And that's also subject to negotiation with things like tipping baskets and caps on what you're willing to spend and can spend. And then a big one that Griffen and I always deal with is who's going to control the defense between the buyer and the seller. And of course, as we rep the buyer, we want the buyer to have a say in who's essentially defending them, and that they're competent enough. Even that comes up in negotiation. So another popular question that we get, oh, sorry, Vince, go ahead.
No, I was just going to say it's interesting because popping up in the feed right now, somebody's asking a question about purchase price holdback and escrow particularly. We haven't quite talked about escrow, and they're asking, how do you do it at a bank? And in my experience, it's not a good fit. Like, a bank won't handle your cannabis escrow, and especially not if it's cash. Typically, I think a lot of that stuff's handled by third-party law offices. Sometimes the seller's attorney will serve as the escrow with a conflicts waiver and stuff. And typically what will happen there is you'll have your escrow agreement, and people will use things like title company calculators and things to figure out fees, so that, because it's just odd in that it's not handled by banks or title companies in the way that it would be in a non-cannabis transaction. So just to answer that person's question, because it followed on what Hillary's talking about, I want to throw that out there.
Another question that we got, and we get this quite often, is how long does this all take, right? How long does it take to get from an LOI to closing to fully transitioning to new ownership, in our experience?
In Oregon, it can take, so certain states are more transparent than others about where they're at with even processing these things. Oregon, they have stopped updating it online, but they told us, I think this morning when we were talking to them, they're about 2 months out from assigning an application to an investigator. And then if things go well, it usually is another month. So in this state right now is about 3 months. At certain points, it's been a lot longer. In some states, it is longer. That kind of brings up a separate issue of people wanting to get into these businesses faster and signing up for management agreements, which I hate. I hate them so much. I'm going to write about them because they're abused and people make messes in these businesses before the sales close. And just sort of another topic, like, have that on your radar. If somebody's approaching you and saying, yeah, I'm going to buy your business and I'm going to come in there tomorrow and actually start running it, you really better be careful with that for regulatory headaches and cash management issues and just like red flags, right? And a lot of buyers, bigger companies, do that almost abusively, I would say, to smaller companies. Once you let somebody in, it's hard to unwind it. So anyway, timelines. The longer the timelines, the longer the regulatory timelines are, the more apt people are to mess around and do stuff like that. But patience is key in these things, and doing stuff upright, or doing the stuff in the correct sequence up front so there aren't delays at the end when everybody's ready to close, like a simple local regulatory approval or stuff or something like that can really save you some gray hairs.
Yeah, and just to add very quickly, because I'm dealing with a transaction right now that's a little bit unusual in that the timeline can also be affected by local government. For instance, like securing a Lux can take a lot longer in certain counties than others. And so that can mess up this timeline that Vince was talking about, where typically within 30 days when you submit a LUTs in most counties in Oregon, you're going to get it, assuming you meet all the requirements. But then others are just have more stringent requirements, and it's a lot more difficult to gauge how long that process is going to take. And so that inevitably delays the rest of the process, including submitting your application with the cannabis board in whatever jurisdiction you're in. So that's
for those not in the know, a LUX is a land use compatibility statement. It's a form of local approval in Oregon. One thing I'd also say, and it really ties into what Hillary and Griffen said, especially about non-cannabis lawyers drafting these deals, is I've seen deals drafted. I've seen a bunch of them, asset and stock purchase agreements, where they're great, they're good contracts, they're built out on indemnities and reps and all these things we're talking about, but they don't have any sort of compulsion in them for the buyer to get in there and start applying for the license on day one, right? And they don't have any mechanism for the seller to get in there and have oversight, like access to the actual person's license applications dashboard. And I've seen buyers either willfully or more often just drop the ball type stuff, not get their application in. I thought somebody else was doing it. 3 months goes by, are we ready to close? Nobody's even applied for regulatory approval. Oh my goodness. So I think that's really important stuff to draft into these contracts, because, how long is it going to take? That's partially a function of where the state's at with these things, but it's also a function of how proactive the parties are.
Mm-hmm.
There's a real simple way to do this too, I think, which is it's a drop dead date, meaning if a closing doesn't happen by a fixed date and you negotiate what that date is, then either party can walk, right? And so it keeps the buyers and the seller motivated to get their job done. And oftentimes when you have a drop dead date, if we get, if it's October 1st and it's September 25th and everyone's trying to get everything done but needs an extra week, usually the parties are accommodating. But, it's always good, depending on who you are, what side of the deal you're on, to have a tight drop dead date that makes people act very fast and not drop the ball. But in a state like California, where, if you're in a certain city that I live in and you drop a change of ownership box request into the regulator, it could be months before anything comes up. I mean, there's a time in LA, you could just, it could take a very, very long time, right? And so it's part the clients hate, because we can never tell them, oh, it's going to take 3 weeks. We just can't, there's no way to do that.
Yeah, when government approval is explicitly involved in your M&A, it's a bit of a roller coaster and an unknown. So I too am an advocate for the drop dead date to incentivize performance between the parties, but I pump the brakes when it comes to tying that date into what the government is going to do, because nobody knows on either side of the aisle, and I doubt that anybody wants to bear the risk for what regulators and bureaucrats are going to do with the fate of their application when they change rules constantly or the interpretations are different from licensing analyst to licensing analyst. So just a word of caution on those drop dead dates. Now, earlier in the presentation, someone had asked about valuation and whether these really, really big deals, which are probably mostly cash and stock consideration, probably more stock than anything, do they impact the valuation of other M&A transactions, or is it really still localized where it only matters what's happening, within the four corners of your state?
That's a good question. I could talk about that. I don't know how much effect those really big deals in the valuations have on these local, closely held business sales between small operators. I think not a lot. And I think, you could certainly quibble with a lot of those valuations. I remember when the first Oregon cannabis unicorn was purchased for $1 billion, cash and stock, Curaleaf transaction. I wrote about, that seems inflated to me, and I wrote about why, and you can get into all that. I think it is important to understand what's market and what's customary in your jurisdiction with respect to valuations. I think it's not a traditional industry. Most industries, people still buy and sell things on multiples of EBITDA, right? EBITDA is earnings before income, taxation, depreciation, amortization, I think. Just kind of like traditionally people used to buy stocks based on PE ratio, right? It's not really like that in cannabis, and certain industries have moved away from stuff. It's not really like that in buying and selling tech businesses anymore, right? They're buying and selling based on what they have for subscribers and market share, not so much earnings. Cannabis is weird. In Oregon, people, yeah, it's not EBITDA. It's not necessarily the market approach or the asset approach or the income approach or all these traditional valuation metrics. It's some percentage of sales usually. I mean, that's the most common metric people usually talk about. They say, what was your revenue last year, last 2 years? Oh, really? Your store did 1.5 million in sales? Well, 1.5 million sounds like a fair purchase price in the city of Portland. Maybe it's discounted in outlying areas. And certain buyers, like we represent, bigger private equity buyers, they have more sophisticated metrics for looking at that stuff, and they kind of pencil it out and figure out ultimately whatever margins are, NOI to use a real estate term. But when talking to sellers, they'll end up talking through basically 1x revenues or getting close to whatever percentage of revenues is, because that's the lingua franca of the Oregon M&A scene. So you've kind of got to know your way around what local custom is, and you should do some research before agreeing on a price. There are brokers in every jurisdiction. There are ways to get information as to other business sales, and it's kind of a fast-moving space. But to circle all the way back around, I don't think these big, publicly held company deals have a lot of effect on the fast-paced, smaller M&A market transactions we're seeing in our various states.
Yeah, I think that's right. Kind of stemming off of valuation a little bit, not necessarily, not really, but fees to get these things done and out the door between the brokers, the lawyers, other collateral fees stemming from the transaction like diligence. What do you guys think the ballpark is for your average buyer? Not some huge mega sale of multiple retail locations, but let's just say acquisition of a single cannabis business on the West Coast. What kind of fees are we talking about? What should people expect?
Broker fees are different than attorney fees. Brokers usually come in as a percentage of the deal, whereas attorneys are usually still hourly in M&A, although I've seen people agree to flat fee and percentage things there too. Brokers typically 2.5 to 5% of sale consideration in my experience. Attorneys, it depends on the deal. If you're doing one of those little naked license deals like Natalie was talking about, and it's $200,000, and that's literally all it is like no assets going over, just one person replacing another as a licensee at a place, maybe you can get away with paying $5,000, $7,000 to a lawyer in the best circumstance. If it's a bigger, kind of more complex deal, heavily negotiated, confusing diligence, difficult attorneys, to be honest, on one side or the other, difficult sellers on one side or the other, those costs can go up pretty quick. Attorneys have a hard time estimating those things sometimes at the outset, but what they can do is kind of talk to you face by face and say, well, now this happened, here's what you can expect. That's the best way I can probably answer that question.
Yeah, fair enough. And then as far as taxes go, and really successor liability, what is the buyer assuming relative to taxes in both a business purchase and then obviously in an asset sale, if any?
I'll take this one. I mean, if it's a business purchase, the answer is everything, right? All liabilities of the business still remain with the business, and you're buying the business, so you've now walked into that potential mess. There are ways to make, indemnification is probably the easiest thing you can do to make a seller continue to be on the hook. So if they didn't disclose something, for example, they indemnify you. So if the government comes knocking at your door and say, hey, you owe us $100,000 for some kind of tax, then you just say, hey, indemnify me, right? It's not perfect, because what if they just disappear and say we're not, or just don't respond or something, or fight you on it. In an asset purchase, it's a lot different, right? Because you're not buying the business. The business is typically the thing that owes the taxes. The business is the thing that owes the debt. I suppose if it turns out that the asset was collateralized in favor of some third party, so meaning if you were to buy a machine, right, and it turns out that the seller of it had done equipment financing and the finance company still had some collateral interest in it, well, there'd be a problem, because they could come and potentially take that machine away, right? So that's why diligence is key, and you're going to want to get any contracts. You're also going to want to make sure the agreement requires them to hand you title to the goods free and clear of any encumbrance, so on and so forth, right? But, that's M&A deals when it comes to either mergers or business acquisitions, just much more hairy in terms of the potential liabilities that can come over. And even when someone says there's no liability, even when you do thorough diligence, like we see stuff coming up so much post-closing, and that's why what Vince talked about, the indemnification escrows and holdbacks and things, it's just so key if you can get it, if you're a buyer.
And we've got about 10 minutes left. And I do want to touch quickly on real estate, because a lot of these transactions implicate a purchase of the real estate. A lot don't. And obviously we've talked about having to get landlord consent to assign the lease, et cetera. But when we do M&A that has a real estate component, which it almost always does, obviously, because of the license, should buyers also be diligencing the real estate impacted in the transaction?
I mean, yeah, whether or not you're buying the real estate, you need to do some real estate oriented due diligence. If you're buying the real estate, a lot of that can be sort of, I guess, shortcut in the sense that you get a title report, right? Hopefully you're finding a title company that's willing to work with you, and hopefully the real estate portions even close through title. But that's sort of a formulaic standard diligence process where you get the title report, you read it, you say, okay, what are they listing out as exceptions from title? What is it that they want to ensure? Am I cool with that? Do you want to fight them about some of those? Try to change their minds. And then you also want to look at basic ordinance stuff like zoning. What does the zoning code actually allow for this? Are there any possible changes coming up? Will I be grandfathered? All that sort of stuff. I've seen cannabis businesses cited in places where the zoning is actually non-compliant, and it's just, if you get that stuff wrong, it can be hairy to say the least. You want to know about easements, like recorded and unrecorded encumbrances. You get lot book reports, things like that. So anyway, you want to go through your sort of standard real estate due diligence process when buying a piece of real estate. With respect to if you're just buying a business situated on land that you're not going to be buying, I think you still want to look into it. You want to obviously look at the landlord and the lease situation, as Griffen said. You want to see how much time do you have left on the lease? Do you have renewal rights? I mean, are you going to be able to even operate your business there for more than a little while? How much control do you have over that? It's helpful if you can even learn a little bit about what the landlord situation is, even if the lease is really good. Is the landlord a very old person who, somehow some trustee may take over this thing and not want a cannabis business there all of a sudden? I've seen that happen. In theory, banks can always call the loan on a piece of real estate if they learn or know that a cannabis business is operating there. So, and I've seen that happen too, which is kind of shocking. I hadn't seen it happen for years, but I've seen it happen a couple of times recently where a bank will sort of, I guess, wise up and say, hey, there's a loan on this property, we're carrying it, and you're operating a federally illegal business here, and we're entitled to accelerate all the amounts due under the agreement. And so I don't know if you can often get that far. Often a landlord's not going to want to tell you about their personal, financial situation with respect to the property, but sometimes they do, and that stuff's just good to know. It's good to have as much information as you can get. So yeah, you got to diligence your real estate, whether or not you're buying the land or just leasing it.
Here's one other example of that, why this can be so toxic. If you're buying a business that has a lease, imagine the business has some undisclosed environmental, they dumped oil or something, right? Then at the end of the lease, the landlord's going to say, all right, now you pay for this, right? So you walked right into that liability. And so you just got to find that out. Yeah, it's key.
And just from a structuring perspective and a drafting perspective, I'd like to know your thoughts. If the real estate is implicated as part of the purchase price, do you make that its own separate contract because it's such a different bundle of duties and rights, or do you somehow incorporate it in the definitive M&A transaction itself without a separate agreement that we'd normally see if we were just purchasing the real estate?
Griffen, you want to answer? I saw you nodding, or I could answer.
Yeah, I think it's like very, I've seen people do it. I've seen purchase agreements that buy multiple businesses. I mean, typically that kind of stuff is a really bad idea because the reps and warranties and obligations, they're just so different when you're buying a business versus a piece of land. If you look at a purchase agreement for real estate versus a purchase agreement for a business, they're completely different looking. So trying to pack that all into one agreement, some people might think, well, it'll save costs. I'll only have one agreement, right? But in fact, you just end up spending so much more time trying to massage the agreement to fit that it's just better to use the normal stuff, right? The normal purchase agreement frankly, when you buy real estate, a lot of it's done on prepackaged forms anyway, as opposed to M&A, which is usually just a form that a firm will have and tweak to the specific deal.
I think in most situations too, you want to think about, I'm sorry, last point on this, you want to think about closings and whether you want the closings tied together, and in almost all cases, I think you do. I got brought in late on a deal, which is still going on, it kind of drove me crazy because the people all agreed to close on the real estate and even certain business assets ahead of the rest of the transaction closing. And that can be a mess, right? Because what if the real estate closes fine, but then something happens on the other side? There's no regulatory approval. Then the buyer ends up in a position where, oh my God, all I bought is real estate. I didn't actually get the cannabis business that I wanted to have. And that's a recipe for disaster and fights. So I think you want to talk about, like Griffen said, having your 2 different agreements, 3, 4 different, whatever they are, having the real estate purchase agreement separately on its standard form probably, but having the closing conditioned on closing of the asset purchase agreement and have them close simultaneously and tying the agreements together in those and other ways. Because if you don't do that, you can end up in a strange situation, and it's hard to wriggle out of those.
We have a couple more questions that I think are actually pretty good and timely and maybe trending in M&A. One of them is, are we seeing more reps and warranties insurance in cannabis dealings? And I haven't actually seen anybody be able to pull the trigger yet, but I definitely have seen it negotiated and tossed around. What about you guys?
Haven't seen it on a deal. I mean, we don't always know everything that's going on in the background of every deal with respect to things like that. I personally haven't come across it or helped anybody acquire it. I don't see why you couldn't get it though, in the sense that a lot of insurance companies are working with cannabis business to issue all kinds of policies. So why not that? I just think it's something I haven't seen yet, and maybe in a bigger deal it would be more important, I would think.
Yeah, I also think it depends on what the reps and warranties are. Maybe outside the standard if they're super customized. We have another good question. How are ESOPs being managed in M&A? Has anybody dealt with an ESOP yet, which is obviously an employee stock ownership plan? And given that the valuations and share prices seem to be dropping across the board, at least in the MSOs that we've all seen, do the employees really ever truly benefit in an M&A situation?
So it depends on how it's done. An ESOP's easier to move over in my experience in the context of a stock sale, because then basically what happens is, the buyer just steps into the shoes of the seller and is now owning and running the ESOP. And all the grants, are assigned, the employee grants to the new company or there's not even an assignment. They just inure to the new company. With an asset purchase, you have to be a little more thoughtful about it, and a buyer should diligence that ESOP and make sure that they understand it correctly and understand if they want to do a new one. But I think it's got to get closed out otherwise, because the shares of the seller company are going away. At least that's how I'd start thinking about it at a high level.
And a question that we got beforehand, which I really like actually, given the nature and the character of the industry, can small businesses actually continue to survive and compete with MSOs buying up as many assets as it seems like they can in the secondary market? Do they have a chance here in the United States? Or are we just headed for mass consolidation and a lot of exits and a few powerful operators in just a handful of years?
I think they got a shot. I mean, Hillary's written about this actually. Each state, it's hard to move from state to state in cannabis right now because of the rules being so different in every state. And that's tricky for MSOs. That gives the little guys more chance to stay and more chance to fight, more chance to get ahead. So I think, given the status of federal law, regional operators are still advantaged and will continue to be. I think you might see a change one day when federal law changes. I think you'll see even more massive consolidation across state lines, interstate and national consolidation. But I think for now, the little guys, I've seen a lot of small businesses doing pretty well despite what we call the Canadian invasion here in Oregon and all these MSOs coming in the last several years. It's not necessarily a market dominated by the big boys, at least not yet, in my opinion.
Yeah, California is pretty much the same way. We're big enough. Everybody still has a place at the table. And M&A is not easy here. Despite the splashy headlines some of you may have seen, many of those deals are not remotely enforceable, at least in my opinion, based on what I've seen and what the regulations say. So I would say it's not all doomsday for the small operator. But many operators are looking to be acquired and to have a nice exit and to at least break even on what they initially invested. And it's been rough. It's been rough to get into the black for cannabis businesses for a multitude of reasons that I won't get into because we are at the 1 o'clock hour, which concludes our hour-long panel. I want to thank our panelists for joining us today. Audience, thanks for tuning in. If we didn't make it to your question, don't sweat it. We always do a blog post kind of summarizing these presentations after the fact, and we will try to get to your questions there in greater detail. So we really appreciate you watching and definitely tune in for the next webinar. Thanks so much.